Good afternoon and welcome to the Employer Link webinar series presented by McNamee Taft. My name is Brad Neese, Managing Editor of Employer Link. I want to welcome everyone joining our broadcast today. We had a record number, 650 people signed up for this webinar, and 19 states around the country are represented here. I would say that's certainly a good indication of just how hot a topic this is for employers. Before we get started, though, let me tell you about a couple of upcoming events. First, our next webinar will be March 27th, and it's titled "To Arbitrate or Not? That is the Question." With incidents of employment-related lawsuits on the rise, along with the uncertainties of facing a jury trial, many employers are considering or have already enacted mandatory arbitration programs. Those essentially require both the employer and the employee to submit any disputes to binding arbitration. The question is whether or not a mandatory arbitration program is truly in the best interest of an employer. Attorneys Sam Fulkerson and Michael Lauderdale will examine that question and discuss the common issues employers must consider. You can find more information about this webinar and register at employerlink.com/arbitrate. After that, in April, comes Employer Link 2013, our annual employment and employee benefits seminar. This year's theme is Government Gone Wild, a lighthearted reference to the increasingly regulated environment in which there are more rules to follow, costlier penalties and lawsuits to avoid, and increased vigilance required on the part of employers. This year we have a new full-day format offering both morning and afternoon sessions. The first seminar is scheduled for April 23rd in Oklahoma City, and we have a new venue for the Oklahoma City seminar. That's at the National Cowboy and Western Heritage Museum. And then on April 26th is the Tulsa seminar in our normal venue at the Renaissance Hotel and Convention Center. For more details and to register, go to employerlink.com/seminar. Now just a few notes about today's presentation. This program has been approved for 1 hour of general recertification credit through the HR Certification Institute. For those who pre-registered for HRCI credit, we will be sending a follow-up email in the next day or so with program details about today's webinar. Second, on your screen, just below the slide presentation area, you should see a tab called Supporting Material. There you can download a PDF version of today's presentation materials. And also, for those who are regular participants in our webinars, you will see that we do not have a tab for submitting questions. This time, we solicited questions in advance from early registrants so that our presenters had the opportunity to incorporate those answers into the webinar presentation. We had some great questions submitted, and that certainly helped shape today's discussion. Our presenters today are McAfee and Taft attorneys Charlie Plumb, Paul Ross, and Nathan Whatley. All three represent employers in all phases of labor and employment law, including disputes before state and federal courts, regulatory and administrative agencies, and arbitration panels. In addition to regularly presenting at our own webinars and seminars, they are also frequent speakers both locally and nationally. They are contributing authors for a number of industry and professional publications, and they are a regular resource on employment law issues for news media outlets. Thank you, all three of you, for participating today. Charlie, I'll get things started by turning it over to you.
Thanks, Brad. Guns in the workplace are a subject many employers are considering and addressing right now, and there's a number of reasons the issue of guns in the workplace are on everyone's minds. We've seen a change in laws, not just in Oklahoma but nationally, that are causing this to be more prevalent and more an issue more employers are addressing. Recent incidents of workplace violence have caused this to kind of become a hot topic, and we're also seeing a lot of instances in which employees are asking questions of their employers about whether they have a right to carry or possess weapons on property or at work. Another issue we see is a lot of misinformation. So the goal of our webinar today on guns in the workplace is, number one, to really try and cut through misinformation and realize that this is not an issue where one size fits all. Employers need to realize that gun policies have to be tailored to the particular circumstances and take into account different risks and circumstances that may not apply to everyone. The other idea we hope to get across today is the idea that a gun policy does not exist in a vacuum. If you have a gun policy in place, it should be a part of your comprehensive workplace violence policy. So what we want to do in today's presentation is start out with an overview of what's happening around the country in terms of weapons laws and what employers are doing around the country in response to those laws, hopefully give us some ideas of perhaps trends or suggestions that are working. Then I'll take that section. Nathan Whatley will pick up our middle section where he'll be educating us about the Oklahoma laws that are specific as to weapons and their interplay with workplace laws involving weapons. And then Paul Ross will finish us up with a section about what you as employers should consider when crafting your own workplace weapon policy. So with that, let's start with workplace weapon laws around the country. We need to realize that issues of gun ownership and possession, as they stand right now, are controlled by state laws. So it's state-specific, and that can be a particular challenge for multi-state employers. What is permissible or what is legal in Oklahoma may not apply if you have facilities in other states. Right now, more than 15 states have laws addressing guns on employers' property. Originally, those laws seem to have been concentrated in the western and southern states, but now those laws or similar laws are trending really everywhere. And they address the ability of employees to possess concealed and unconcealed weapons. Now, employers' responses around the country when it comes to weapons in the workplace, first of all, employers are developing specific gun policies that apply to their workplace. And as I mentioned in our introduction, typically a gun policy is part and parcel of an overall workplace violence policy. Employers are also recognizing that there are skills that can be imparted to supervisors or other employees that help people to recognize potentially violent employees or circumstances. A number of employers in Oklahoma and elsewhere have picked up and adopted some training for supervisors and employees to help them look for signs or conduct that are sometimes a precursor to violence, the idea of trying to address potential violence before it explodes in your workplace. We're also seeing a trend where part of a violence in the workplace policy, employers are becoming more active in offering EAP, that is Employee Assistance Plan resources, and making those available both to family members or employees, again, with the idea of reducing risk for violence in the workplace by getting people, if we can recognize potential problems, getting them to see proper treatment. One of the moving targets right now when it comes to workplace gun possession is what potential liability an employer might face when it comes to instances of violence or potential violence or gun possession in the workplace. And a couple of trends we're seeing now is when guns and possession of guns and perhaps use of guns in the workplace leads to workers' compensation claims, and also negligence claims or vicarious liability responsibility for employers for injuries, and that may be injuries caused by guns in the workplace, injuries sustained by coworkers or perhaps third parties, non-employees. I mentioned that over 15 states right now have laws addressing employees' rights to possess guns on employers' property. A few common features with these laws. First of all, when it is permitted, it tends to require a license to possess in order for you to bring up a weapon onto the property. These laws tend to require that they be not only possessed by a licensed individual but contained in a locked vehicle, and many of the states specify that the weapon has to be out of sight. It can't be seen in the vehicle. Now, when we found ourselves in states that permit guns and vehicles on employers' properties. Here's some of the issues and problems that have arisen. First of all, if you're in a state that permits guns in a vehicle locked on an employer's property, does the employer have a duty to monitor? And what I mean by that, there's been litigation and some statutory revisions addressing whether the employer is obligated to check that individuals that have weapons are licensed, whether the employer is obligated to make sure the vehicle with a weapon is in fact locked, and whether an employer or its representative is required to circulate through the parking lot to make sure the weapon is out of sight. Another issue that has arisen is in states that have laws that permit guns in vehicles that are locked on employer's property, what about an employee who is licensed to possess a gun? What if they're using an employer-owned vehicle? Does that right to have a gun in a locked vehicle extend to vehicles that the employer owns that an employee is using as opposed to a personal vehicle? Or what about excuse me, what about instances in which it's an individual's employee, but an individual's own vehicle, but they're using that vehicle during work? Perhaps they're calling on customers in a sales capacity or an inspection capacity, and they're actually taking a vehicle from your property, the employer's property, going to a customer or the public location with a weapon in it. Another question that's arisen in other states is whether if individual employees are permitted when licensed to keep a locked weapon in their vehicle, whether you as an employer can say, okay, I understand you have that right, but I'm going to designate what area of my parking is going to be devoted to locked vehicles containing weapons. And then finally, an issue that's arisen is if you're in a state that permits licensed owners to have guns in locked vehicles at their employer's place of business, are there circumstances where the employer has a right to search those vehicles? Flip side is, if you are in a state which has some ban or perhaps the ability of an employer to limit gun possession in the workplace, what sort of notice are you required to give to employees and the public about what sort of banning or limitation? I mean, do you have a specific signage requirement for the public and for employees? In the case of employees, if you're banning or limiting or somehow circumscribing how I can possess or where I can possess workplace, am I required to have it in an employee handbook or policy manual? We've seen in other states litigation and some statutory and regulatory movement that address the issue of whether an employer can say, well, I'm going to permit possession of concealed weapons in this portion of my plant or workplace. I'll give it as an example, a warehouse or a factory, but I'm going to preclude any possession of concealed weapons in the area of my premises which invite customers or third parties. One issue we've also seen in Oklahoma and other states, what happens if your employees are working at other sites? You may have a rule or policy that permits the carrying of a concealed weapon when licensed, but what if your employees are working at another site as a contractor or a vendor, and your customer or the individual with whom you're working has a very different policy? How is that addressed? And finally, the issue of employer immunity, and that really goes to if you are an employer and you allow, under certain circumstances or in particular locations, employees or others to carry concealed weapons, and something goes wrong, someone's injured, are you as the employer, because you are the employer and you control that property, are you going to be subject to any sort of liability for folks sustaining injuries, or are you going to be immune from a lawsuit claiming injury because all you were doing was complying with the law and permitting individuals to carry consistent with state law? So I'm hopeful. We're getting ready to have Nathan educate us on what the laws are specifically in Oklahoma, but I'm hopeful that that overview gives you an idea of the trends and how other states are addressing weapons in the workplace. Nathan, can you drill down a little bit deeper and tell us what applies and what the rules of the road are when it comes to Oklahoma employers?
Certainly. In Oklahoma, I wanted to start off with the fact that we have statutes that have predated some of the concealed and open carry laws that talk about a general right to possess firearms without any license, and that statute provides that a person is permitted to carry either loaded or unloaded long guns or handguns, open and not concealed, for self-defense, protection, or other legitimate purposes on property that is owned, leased, rented, or otherwise controlled by the person. This, of course, would include places of business, places of employment, where a business owner would have the right to possess openly firearms for protection or other purposes, or to allow employees to do that. So that exists regardless of the status of someone as a licensed permit holder. Oklahoma also has a set of statutes that deal specifically with carrying a handgun with a license. And this is the Oklahoma Self-Defense Act, and it provides for issuing a handgun license to qualified citizens of the state and lets them carry either openly or concealed in a number of public locations. The Oklahoma Self-Defense Act provides some exceptions on places where people cannot carry. Those include government buildings, places where the primary purpose of the business is to serve alcohol or low-point beer, places where pari-mutuel wagering occurs, government buildings where any business is done with the public, or where public meetings are held. But it doesn't exclude people from carrying in parks. Other prohibited areas include school buildings and college campuses and professional sporting venues, and other places where it would be illegal to have a gun under the law. Well, what about these private places that aren't excluded by the Oklahoma Self-Defense Act? Under the Act, property owners, including Oklahoma employers, have the right to control the possession of weapons on their property. And that's the language the statute uses. It talks about being able to control possession of weapons on the property. And that gives employers a lot of flexibility in setting their policies and setting their practices. This would include the right to prohibit employees who have licenses from bringing a handgun into the workplace, or to limit that or structure it in a way that the employer wants to structure it. So it can be anywhere from an outright ban down to a very detailed scheme for how and who can carry and where.
Yeah, Nathan, let me ask you a question about that. Does the Oklahoma Self-Defense Act at all have any provisions at all that require signage when it comes to prohibitions?
No, it does not. And so property owners, including employers, do need to give someone who otherwise would lawfully have the right to carry on their property notice, but there's not a specific way in which that notice has to be given or must be given under the Self-Defense Act.
I've got a follow-up on this, and if I'm looking ahead, warn me, but can I make different rules as far as possession, depending on who the individuals are? Like, for example, could I exclude, let's say I'm a retail operation, or I'm in an office area that may have, it's not unusual for members of the public or third parties to come on. Is it lawful for an employer to say, I'm going to allow my employees to carry, their license to carry concealed weapons, but I'm not going to permit non-employees? Is that fair game?
Sure it is. That's part of the scheme I was just talking about, and the right to discriminate exists there. Obviously, when you're talking about employees, you've still got overarching concerns of Title VII and things like that when you talk about discriminating between groups of employees. But as long as there's a basis for it, it can be between your employees, your customers, it can be between employees that work that have contact with the public and don't. All of those kinds of considerations can come into play, and the employer has a lot of flexibility there, including things such as requiring training, requiring it to be limited to a certain group of employees that have been cleared to carry those weapons. One area where employers don't have the discretion that Charlie touched on just briefly is storing firearms and ammunition in a locked vehicle in an area set aside for parking. I've set out here the language of Oklahoma's statute that deals with this particular question, and it talks about no employer being able to establish or maintain a policy that has the effect of prohibiting someone from transporting or storing a firearm or ammunition on any property set aside for any motor vehicle. And the language that was used by the legislature is very broad. I know there have been a lot of questions and thoughts about are there any limitations employers can enforce here. But I think that purposefully this language was chosen to try and make it as broad as it could be, and that was having the effect of prohibiting a person from storing that vehicle or storing that weapon in a vehicle or transporting it. And it talks about any property for any motor vehicle. Charlie, I know that you and I were talking earlier about, what about designating a certain area? And you had some thoughts about that as well.
Well, it's just a point I've noticed in looking at the trends around the country. There have been some states that either explicitly in their statute or just by virtue of practice, when the laws permit an employee to carry firearms or ammo in a locked vehicle, have gone so far as to designate a specific area where those locked vehicles with weapons and ammo have to be located. And I guess in our statute, it's not that specific. I mean, we could see either argument. Your point, I guess, is it says any property set aside, and I'm taking the position I'm not prohibiting anybody by designating. So I guess
right.
that's kind of uncertain right now.
It certainly hasn't been taken up by the court, but I think when you put together the language saying would have the effect of prohibiting, and then talks about any property for any motor vehicle, that the cautious way to proceed would be not to set up policies that would have that effect. Like I said, we don't have an answer yet from our courts.
Nathan, let me follow up on a couple of other things that Charlie talked about in his overview of other state laws, and let's see what we know about Oklahoma's position on these. But the first one would be, have you seen any cases, and I personally haven't, but have you seen any cases interpreting this statute and whether or not employer-owned vehicles are covered by Oklahoma's prohibition or not? I hear that question a lot, and I personally haven't seen any authority on whether or not this statute applies to employer-owned vehicles or not. I'm curious if you have.
I have not either, Paul. The only cases really interpreting this have been just the initial challenges and then one subsequent follow-up challenge when the statute was amended, which really talk about the criminal nature of the statute and talk about the fact that it's not an infringement on the property owners that's constitutionally infirm. So no one has gone that far. Now, one thought that's out there is there's probably a difference between a vehicle where you come in and pick up your delivery van from your employer's place of business versus one that's totally checked out to the employee and they take it home overnight and basically that's their vehicle. I could see a distinction maybe being made there.
And I would probably be a little bit more aggressive. We are kind of working with a blank slate right now. Conceptually, if we look at the statute you've shown us, it just talks about a locked motor vehicle. It doesn't talk about who owns it. One argument I would make that says if it's the employer's vehicle, they control it. Your argument, I think, is a very good one. If it's something they're picking up and using, that's more clear. But I take the position that the statute seems to recognize the employer's ability to control at some level its property, and I might be willing to be more aggressive and say, look, a vehicle, even if I give it to you and you take it home and you're supposed to be using it in the course of employment, I get to control that vehicle. And I might go so far as if you don't like it, then use your own vehicle.
Right. And
we don't know the answer.
We don't know the answer, but eventually we may see a case where somebody has that approach and it gets challenged. I'm sorry?
I was going to say one more thing on Charlie's list. What about the idea of immunity in Oklahoma. Does Oklahoma's statute address the idea of employer immunity for gun-related incidents?
Only in the context of this particular provision, which requires them to allow storing of firearms. As part of that statute, it also talks about the employee or business owner not being liable in any civil action for an occurrence that results from the storing of a firearm in a vehicle. Now, the exception would be if the property owner themselves was the one that went out to his or her car and got the weapon and used it in a criminal act, the immunity wouldn't apply. Otherwise, that was sort of the give back. You know, Charlie talked about the give back in some statutes of you can designate where and when. Sort of the give back here to try assuage some of the concerns was providing some immunity for property owners.
So in Oklahoma, at least as far as we know right now, the employer cannot be held liable for some injury that results from a properly locked weapon in a car in his parking lot. But what does the law say about weapons possessed elsewhere? Does it address immunity at all?
It's not addressed in any of the other sections of the Self-Defense Act or Oklahoma's firearm statutes.
Okay.
Well, not in terms of immunity. We'll talk in a little bit about the use of deadly force and some of those presumptions, but not in terms of immunity. The way I mentioned before that one of the cases talked about this statute being a criminal statute, and in fact there are provisions that make it a misdemeanor, but it also has a provision that allows an employee who's been denied the right to store a firearm or transport in a vehicle under the statute to sue the property owner or employer and obtain damages and attorney's fees.
Would that apply, what you just said, Nathan, to an employer who improperly fires an employee who had a gun locked in their car?
Yeah, I think so, because again, you go back to the language that says the policy or action that has the effect of prohibiting someone from being able to exercise the right under the statute to store that firearm. Some additional statutes in Oklahoma that are important for employers to be aware of. We've got a statute that makes it illegal for an employer, a private employer, to ask any applicant information about whether they own or possess a firearm. Now, that doesn't mean they can't ask them if you're possessing a firearm at work, but whether you own one, you have one at home. This is purely set up as a criminal statute that provides for misdemeanor type punishments.
And that's only at the it specifies applicants. It's at the hiring stage. It's not addressing existing employees, correct?
That's correct.
And it looks like to me that's a kind of a non-discrimination. You're not supposed to be making hiring decisions based on whether or not I'm a gun owner.
That's correct.
Okay.
It also, a section of the statute applies to public employers and public officials who are similarly prohibited from asking applicants that type of information. There, the public official is said will be deemed to act outside the scope of their office and can't have immunity from any type of tort claim that might result. So those are some of the statutes that deal with possessing weapons, asking questions about weapons, that talk about what rights businesses have to regulate the presence of those weapons. Also, an important statute is one that talks about what can be done with those weapons if they are present in the workplace. In Oklahoma statutes dealing with the use of deadly force, we have a statute that's often referred to as the Make My Day law. That's not really what the title of the bill was, but it encompasses places and presumptions that deal with the use of deadly force when somebody is in their home, in a vehicle that they have the right to be in, or in a place of work. And I've just included the portion here that deals with the place of business. And that section provides that the owner, manager, or employee of a business is presumed to be justified in using deadly force under certain circumstances. And those include circumstances where the person who force is used against was in the process of forcefully and unlawfully entering the business, or had unlawfully or forcefully entered the business, or where the person against whom force is used has drug someone out or attempting to take someone out against their will from that place of business.
Now, when you talk about those, Nathan, those legal presumptions, I mean, the lawyers know what those mean, but the importance of those are, is this in a criminal setting or is this in a civil setting where these presumptions apply and really protect individuals who've used that force to protect themselves?
Well, it doesn't differentiate between criminal or civil, so it's going to be important in both. One, if the person who shot, for instance, as they're breaking in, survives and sues in civil court, but also if a criminal prosecution were to be considered. What it means is that anytime deadly force is used, it can result in criminal charges, or it can result in a homicide or an assault at some level. A defense to that is where a person is defending themselves or their place of business or their employer or their employees. There can be a self-defense that's put forth. In order for that self-defense to be available, there has to be a perception that either that person who used the force or their employer or their employees were in imminent danger of either death or serious physical injury. And this creates the presumption to be there. In other words, this says if someone's forcibly breaking into your business, there's a presumption that they mean to do serious physical injury or cause death to the people inside. And by doing that, it takes away part of your burden and puts that defense, makes it a lot easier to have that defense available. And that can be, again, under the statute, the owner, but it also can extend to employees of the business if they've been authorized to carry in the workplace.
One of the points you make, Nathan, is at least in Oklahoma, I have some freedom to tailor the scope of people carrying weapons, except for an individual's right to have it in a locked car. Let me give you an example. You and Paul work for me, and I'm a medium-sized employer, and Paul has been I know Paul's been a lifelong gun owner and very, very serious, very stable, hunted all his life. I don't have any problem with Paul carrying a concealed weapon. Now, you, on the other hand, Nathan, this may hit a little close to home, okay? You're also licensed, but I haven't been that impressed with your judgment. You've been late to the gun game, okay? You've kind of got caught up in all this, and you're talking a lot about gun usage, and I'm a little bit concerned about you. And you're going through a divorce, and things don't seem to be just right with your life. So you know what? I'm okay with Paul. I'm going to say, Paul, you can bring and carry a concealed weapon, but Nathan, you're too much of a loose cannon, so I'm not going to give you that same right. Problem? No problem? How do I address that?
Certainly from the laws dealing with property owners controlling firearms on their premises, it's not a problem. You've got that leeway. You've got that discretion. And from a practical standpoint, I think that those are some of the right considerations that employers would look at. Again, the only caveat, which we're always throwing in caveats as employment lawyers, is the backstop of Title VII and other anti-discrimination laws. That if is there a difference in the demographics between me and Paul that where I'm in a protected class and might say, hey, you're not allowing me to defend myself because my religion, or for whatever reason, or because I'm too old to see the front side of the gun, that kind of thing. That would be the only problem. But from a standpoint of the laws governing the possession of firearms, certainly you can make those kinds of discriminations, whether it be based on training, temperament, a history of having disputes with your coworkers. Any of those things certainly could filter into the mix.
And I think we're getting ready to get into Paul's portion of our presentation, which is really weighing all the things we're talking about here. But one thing I think this discussion should impart to our listeners is the idea that if you do allow weapons on your property, concealed weapons by licensed individuals beyond into locked cars, you're going to be in situations where you potentially are going to be picking and choosing. And Paul, when that's the case, what do you see as the issues our listeners ought to be taking into account.
Yeah, and I think that's a really good segue for us into what is really the primary question before us right now, which is, should employers prohibit firearms on their premises or not, to the extent they have the ability to make that prohibition under the laws. And there are other states like Oklahoma that give some limited rights to employees to have weapons, particularly in parking lots, but there are others that don't. And so the question is, should we as employers prohibit our employees from carrying guns? And I would say that at least in the 10 years or so that I've been doing this, it's been fairly standard for HR departments or employers to prohibit weapons in their entirety to the maximum amount allowed by law on workplaces. That has been the policy that I see almost universally when I review someone's policies or handbooks for compliance with legal issues.
And I guess, Paul, what you're saying is those that have it. I don't.
Yep.
There's certainly a lot of policies that are silent on the
That's
issue,
right.
and I think people need to realize that without speaking up, if a person's licensed to carry, the workplace is usually a place where that would not be banned by the law, and it needs to be addressed by the employer somehow or another.
That's exactly right.
So that's an excellent point. The point number one is, if you don't have a policy and you don't have signs up, then I get to bring in my concealed weapon, correct?
As long as you're licensed and it's a lawful possession, That's right.
Okay.
And obviously the employer could still ban that by simply speaking to the employee and telling them, hey, wait a minute, we're not going to allow weapons here. But it's always best to communicate things consistently and broadly so that everybody knows what the rules are.
And particularly if you're in a premises where you have some non-employees, it's one thing to have in your handbook, but if you're going to prohibit it generally, that's why we're seeing signage going up, right?
That's exactly right. And, what really prompted this discussion and this webinar topic is that as a group, our practice group has received a lot of questions recently in the wake of kind of these public tragedies that have happened over the last year or so, reevaluating those published policies. Should we ban weapons or not? And what has been an automatic conclusion by some in the recent past is being reevaluated now. And maybe should we be entertaining the idea that we should have some kind of a hybrid policy where some people are permitted to lawfully carry guns, and should we continue with a complete ban to the maximum amount allowed by law as we've done in the past? And so unfortunately, we strive really hard as employment lawyers to give you black and white answers where the law allows it. But this is not a topic where there is a black and white answer. There's no easy answer on this, and there's no canned policy that is attributable to every employer. It really boils down to a significant set of competing rights and different circumstances for each employer that may justify having a policy that does allow some firearms. And we'll talk about what some of those things are going forward. So here are some of the factors that are commonly recognized as promoting a complete ban on weapons and firearms. Number one, it's important for everyone to know employers are the primary target for lawsuits when there's a workplace shooting. Even though traditionally, in almost every case that I've read about, the shooter is not the employer. It's typically not done. It's usually by an unstable person who has snapped for some reason. But in almost every case that I read about following a workplace homicide, it's the employer that gets sued. And so most policies are tailored as a way to try to limit that liability in some respect. And employers want to be able to say to a judge and to a jury in response to an accident or into an intentional shooting like this, that they had policies in place to try to prohibit this from happening. They took steps, although they weren't successful, to prevent this from happening. And so it's primarily, or not primarily, but one principal purpose of this type of policy is to be able to show that the employers took steps to prevent these types of things from happening. Another factor that weighs in favor of a ban is that victims can allege that an employer's failure to ban weapons caused the harm they suffered. So if you had simply had a policy in place that prohibited Paul from carrying a weapon into the premises, then he wouldn't have been able to snap and injure or kill a coworker. And that's a very common strategy used by plaintiffs' attorneys after these shootings in a situation where no policy existed prohibiting the weapons. Other factors are the risk of accidental shootings or friendly fire incidents. And what I mean by those are, it is a distinct possibility that if I'm a licensed gun owner and a licensed carrier that lawfully has a weapon in my desk, for example, and I mistakenly conclude that Nathan is engaged in some behavior where he's trying to injure Charlie, I might take out my weapon and shoot Nathan and be wrong about that. I might have been mistaken about Nathan's intent and what he was actually doing. And by having a policy that prohibits me from having that weapon in the first place, that risk goes down. And that's certainly something that you'll see in the literature discussing factors that favor banning weapons. The other one that, and this commonly comes up in criticism of the parking lot laws, is what we call the cooling off period. There is a lot of discussion in the literature about the idea that if I am upset with my employer over some action that's been taken against me, if I am able to just walk to my parking lot or walk to my desk and get a weapon that's readily available, I might do some damage or cause some harm that I otherwise wouldn't do if I had to instead drive all the way home to get a weapon, and maybe by that time I will have cooled off. And so there's a lot of discussion about that cooling off period as being a positive reason to ban weapons in the workplace.
Paul and Nathan, I don't know if you've run into this, but I've had a couple of employers that I work with bring to my attention their insurance policies may have a requirement that they have a weapons ban. So one thing the employers that are listening to today's webinar, one of your checklists, go back and look at your insurance policy or talk to your insurance consultant representative, because that may figure in your decision process.
That's absolutely right. In fact, that was one that I had written for myself on my notes here to make sure I remembered, and there was one other one that I put on there, which you touched on earlier just briefly, is that you may also have contractual agreements with your clients or with other people or businesses that are important to you, that you may also have obligations to ban weapons or at least ban weapons by certain individuals in certain places that you need to make sure you're aware of, and your policy provides for adhering to those contractual requirements as well.
Are you talking about an example where perhaps you permit, one employer permits possession of concealed weapons, but their employees may be working on a site where another employer prohibits that?
Absolutely. That's exactly what I'm talking about. The clearest example that I'm aware of where I've seen this would be a drilling site. The actual superintendent of the entire drilling operation may completely prohibit the possession of weapons on that entire drilling site, and you as a subsidiary provider of some small service may allow your employees to carry weapons, but they may be prohibited on that site. And usually that's addressed in contracts that govern those subsidiary relationships. So that's certainly something to keep in mind when you're considering these policies. Now let's talk about the flip side of that. What are the factors that weigh against banning weapons completely? Believe it or not, it's the exact opposite side of the coin that we talked about before. There is also litigation out there where victims of shootings allege that an employer's policy prohibiting weapons denied them the ability to defend themselves. And so it basically becomes a situation where you can be, for lack of a better word, you're in trouble no matter what you do. Because if you prohibit weapons, you're now in a situation where somebody could allege, I could have defended myself had you not put me in a position where I couldn't carry my weapon to work. I will tell you that these suits are not nearly as common, and I've only seen a couple of instances where these have actually been attempted, and one of them was very recently with the Connecticut shootings, and it was dismissed fairly quickly thereafter. But there's a lot of literature about that. There's a lot of legal discussion about that, and I think that cause of action is going to gain some momentum over time. And so we really have to take careful consideration before we just outright ban all weapons in all circumstances without really discussing the risks that are out there particular to our business and making sure that this is the right way to put our employees in a situation that they're not exposed to heightened danger because of our policies. Particularly where I've seen that discussion come up is retail environments, environments where there's a lot of risk for late night activity or activity involving alcohol and drugs, those types of situations where the risk is heightened to begin with, and then we take away that right to defend oneself. It becomes a problem of you becoming an insurer of the safety of your employees. And so that's certainly something that you should consider at long length, in my mind, before there's a complete ban on weapons. Other things that I hear and I read about that are certainly discussion points in the policy-making decisions are, we don't want to create a victim zone. We don't want to create a situation where a person snaps, starts shooting at the workplace, and it's 10 minutes before a police response can be on site. And in that 10 minutes, lives are lost. And it becomes a very significant consideration to make sure that an outright ban is the right choice. And if you have a hybrid policy where you've got some on-site armed security, you certainly limit the exposure that comes from those long response times. And then the one that I think is very seriously needs to be considered is whether or not a policy in and of itself is really a deterrent to anyone who intends to break the law to begin with. Or does that policy instead simply limit the law-abiding person's ability to carry a weapon? And these are all things that should be considered in determining whether or not we have a circumstance where a prohibition is appropriate. So that brings us back then to the question, should we prohibit or not? And in general, an employer has to understand that workplace violence incidents, including accidents, are likely going to result in that employer being put on trial. Did you have in place effective workplace violence policies, effective discussion of weapons in particular, and can you show that you made a reasoned decision about where you came out on those policy decisions? Yeah, Charlie.
Like a lot of things too, Paul, when you're working through the weapons policy and your general violence policy, don't miss the training aspect of it, particularly for managers and supervisors.
No, that's absolutely right. And that's something you touched on earlier, which is when you're considering a weapons policy as a part of a violence policy, a broader violence policy, really good policies and really good programs take into account the idea that you have to train those supervisors and managers in what to see so that they can take advantage of those protections that you have in there to keep your workforce safe. And so that's definitely something that you want to keep under consideration. All right, so I'm going to answer some of the questions that were brought up by not just our questions that we received in advance of the presentation, but also just general questions that have come up through conversations with clients. First question, does the law actually impose a duty on employers to protect employees from gun violence in the workplace? And the answer to that, generally speaking, is yes. Employers have to take some very serious steps to evaluate the particular risks associated with each element of their business and protect those employees from foreseeable violence, whether that's the foreseeable violence from a particular employee or from an employment sector or because of where the warehouse is located or because of the crime statistics in that part of the city. All of those things need to be considered, and they all come back to be discussed in that lawsuit that follows an accident. So the answer to that is definitely yes, and there's a number of sources where those duties can come from. General negligence lawsuits, including negligent hiring and supervision and retention lawsuits. Sometimes there are discussions about the OSHA General Duty Clause and its application to gun accidents or intentional injuries in the workplace. Respondeat superior claims basically are vicarious liability claims that could be, for example, they could come from your armed security that you pay to be on site. And if there's an accident or an intentional shooting done by that armed security, that's certainly in the scope and course of their employment, and it could result in liability from there.
You know, and one of the common features of liability when it comes in the context of workplace violence, a lot of times it is a mixed victims. I mean, it's not always employees that are victims. You may have employees, you may have employees' family members, you may have members of the public who are patronizing your business, and potentially you're seeking you're the subject of liability of all those different groups potentially.
That's absolutely right. And then the last kind of source of duty that we want to talk about, and this is important to all of you who are multi-state employers, there are a number of states that have very specific regulations that apply to particular establishments or particular sectors of the economy, like special duties that apply to retail establishments or liquor stores or other types of things like that, and that's certainly worth your research and your investigation. And then a couple of more questions real quick. Does the law protect employers who allow lawful possession of firearms? We've answered that a little bit. The answer to that is yes, some states do to a limited degree. And those are the immunity statutes that we talked about earlier. But those are not very well tested. These laws are so new that there hasn't been very much, if any, reported litigation about how those immunity provisions are going to be applied. So there's a certain degree of caution that ought to go along with whether or not we rely too much on those immunity statutes. And then finally, does the law impose a duty on employers to allow employees to protect themselves? And that's a completely unknown quantity right now, but I do see, like I said a minute ago, a lot of writing by legal scholars about this and potential negligence theories and heightened duties that get imposed on employers to take that self-defense right away from their employees. So that's certainly something that's going to be on the horizon for us to worry about. And then the last question, does the law permit employers to have varying policies rather than an all-or-nothing prohibition on firearms? And the answer to that is yes. And that, as a very practical answer to that question, it's fairly common for some employers to have armed security that's permitted to carry guns. Those people may be CLEAT certified, they may be trained, they may be 20-year officers with a lot of experience with firearms, and that's fairly common to have. The question is, how far can we push that? And we've talked about several examples on that today, but the answer is yes. The employers do have flexibility when it comes to designing their policies and really constructing a policy that is appropriate for their particular circumstances, and it may not be a complete prohibition on weapons. All right, so just to kind of emphasize a few points that we've talked about that we really want to drive home, it is really required that employers make a careful study of all the known risks that particular employer may face based on actual data. The real danger is to make assumptions based on anecdotal behavior. It really does require some good study. We need to really take into account the risks of being silent and taking no action whatsoever when it comes to these policies, because being silent can certainly be interpreted in a lot of different ways, and it can be used against you. So it definitely pays to have a policy, but it should be one that's been really carefully considered. And then the kind of the main point, and we've said this several times, but it really requires employers to have a broad, generally applicable overall strategy to workplace violence that includes training, that includes EAP provisions, and really makes an effort to prevent violence and not just a political stand on guns.
This is certainly an evolving area of the law for employers. And Nathan, I was going to ask you, is there any movement afoot, or have you heard anything about our own Oklahoma legislature looking at amending or fine-tuning or maybe perhaps addressing some of the issues with more detail as the statutes that you've covered currently?
I'm not aware of any proposed amendments to the Self-Defense Act or the firearm statutes. Obviously, one thing that is under consideration right now is school safety, which, if we see a developmental in those areas, and I know some proposals were just released yesterday, we might see other employers look at what model's been adopted there in terms of how they approach safety in their workplaces.
Paul, I think that last slide and your last points are really critical because, I think as you pointed out early on, if there is going to be an event of workplace violence, particularly if it involves weapons, the employer is going to be involved in any resulting liability and litigation. And besides presumably coming up with a better policy by following your instructions on how to craft the policy, going through that process not only ends up with a better policy for the employer when it comes to violence or weapons, isn't that also doesn't that provide us some protection for claims of liability, that we went the extra mile before reaching a decision on how we're going to apply this?
Absolutely, particularly the cases where you're being accused of negligence, because negligence is your failure to satisfy some legal duty, and here you would be able to present evidence of the exact opposite. You engaged in a very thoughtful, technical, detailed discussion of the risks and took these educated and thoughtful steps to try to prevent this from happening.
Great. I think that's great. Nathan, anything else before we sign off to our listeners?
I think we've kind of presented the questions that are out there, and the whole point is what we've said several times, but it bears repeating, is a holistic approach to the idea of preventing violence, whether it's to ensure safety there or to better position yourself from legal claims, but it's got to be a holistic approach.
Thanks, Nathan. Thanks, Charlie, and thank you, Paul. Before we close, just a few quick reminders. First, you'll be getting a follow-up survey about this webinar in the next day or so. Please take a few moments to complete that questionnaire. Your feedback helps us improve our events as well as letting us know what topics and issues are on the minds of our participants. Also, as I mentioned earlier, those who pre-registered for HRCI credit will receive an email in the next day or so with program details about today's webinar for recertification submission. Also, later this afternoon, an archived version of this webinar broadcast will be uploaded to our webinar resource page, and the downloadable version of that presentation materials is also available there. You can easily access that resource page from the homepage of employerlink.com and McAfeeandTaft.com. Again, I want to thank Charlie Plumb, Paul Ross, and Nathan Whatley for presenting today's webinar. And on behalf of the law firm of McAfee and Taft, thank you for joining us for another Employer Link webinar. See you next time and have a great afternoon.